Hi, everybody, and welcome back to Checkmate the Matrix. Today, I have a fantastic special guest for you, a friend of mine, which is Dayne, who's talking about a specific area of law, not just sort of like law or general or common law is what a lot of people would call it. But we're going to actually have a look at family law, but we're going to show you something sort of like about, in a way, like legal versus lawful, kind of. But, anyway, I'll let him get on with it rather than mix him up too much. All right. So welcome, Dayne. How are you doing today?
Hi, Peter. How are you? All good, thank
Good.
you.
I'm good.
Thanks for having me on the show.
Oh, it's an absolute pleasure then. So can you just give yourself like a little bit of an introduction so people get a bit of an idea about the background and, how you got, not specifically this case, but interested in the law in general, and then we'll move along like that.
All right, cool. So yeah, just like everybody else, just living out here, going to work, living my life as you do. And then I had a claim in the family court from the mum to do with a residency case. And at this particular time, my daughter was already living with me for a couple of years, and then the mum filed. She wanted to move away to another country, so then she filed into the claim for a residency order so that my daughter could go live with her in the other country. So I didn't know anything about law. I didn't know anything about the courts. I hadn't, just like most of us, never been to a court, didn't understand how it works or the rules. So obviously I thought to myself, well, I like to do things myself and figure out stuff myself. And obviously you already know that we don't like to our first port of call for me is not to go and pursue a lawyer. I want to think about, oh, is this something I can handle myself? Lawyers are very expensive. We don't have that type of money, most people. And I just believe that I could try to figure it out myself. So I just was on the internet trying to search for things. As you realize that there's nothing you can find that gives you any information. So I ended up going on YouTube, and I found a particular channel. The guy's name was Carl Lentz. And when you find these things, it's hard to determine if what you're hearing is true. So I just had to go on my own judgment. And when I watched a lot of Carl's videos, a lot of them just seemed so right that I thought, well, how could this be wrong? And every kind of devil's advocate question that I would have, I'd hear it in his video of like demonstrating how he dealt with it. So I thought, you know what, this guy sounds like he's talking some truth. Let me have a phone call with him. So you have to donate, have a phone call. And then it was Carl that taught me that there's like a separation in the court where you separate what people might know as the legal name versus your living self. Now, there's a lot of theory about this, in the movement, that are you the name? You're not, the name's not you. You're the living entity to the name. So, again, I didn't know too much about this, and he helped me break it down and understand that. His main thing was that you don't give a court jurisdiction. And that basically means that I'm living my life privately. When I'm living my day-to-day life, I'm living my life privately. So when we're going into a court, this is technically a bunch of other people telling us what we can or can't do in our life and trying to direct us what we should or shouldn't do. In my head, naturally, most people think, well, who's this man or woman that can come in and tell me what to do with my children? Your children, like only you can dictate what you do with your children. There was no fears or anything of harm or anything like that from the mum. She admitted I was a good dad and all them kind of things. So I'm thinking, well, why would I need a stranger now to come in and tell me what to do? So Carl's method was teaching me, was exactly that, but kind of telling the judge in, let's say, the lawful way of how to say that without saying, who are you? So to not give jurisdiction is to not allow the court control over you and your affairs. And that comes with little steps throughout the court process and changing the language and the words you use, because they have a set of what we call legal words. And when you use legal words, you end up becoming under a legal capacity, as we say. And then if you're in the legal capacity, you end up following the legal framework. And these are little ways that they can kind of manipulate you into acting in these capacities, because most people wouldn't recognize, most people don't recognize or have never heard of this type of thing. So You know, Carl taught me a one-on-one process, you know, certain checkpoints through the court process. The first checkpoint when you go into court is, you know, to not stand up for the judge when the clerk says all rise. The reason that is because, you know, there's a few like things in like legal maxims that you use, and you kind of pull things that govern them that you can use to help you. So one of the legal maxims is all are equal in law. So knowing this, it backs up my reasoning of why I'm not going to stand for the judge, because if we're all equal in law, why would I stand up for another man who's my equal? You know, should I stand up for another man who's my equal, might perceive that I put him as a higher status than me. And if I do that, if I put another man in a higher status than me, then it looks like I'm giving him authority over me. And that's how it's presumed in a court. It's all presumption. And that's how it's presumed, you know, kind of like if someone says something about you and you don't rebut it or challenge it, then it seems like that what they're saying might be true. So
yeah,
that type of concept.
I mean, that there, right? So just what you're talking about really is their language.
Yeah.
So the court's language is like legalese, yeah?
Yeah. It's legalese.
So, I mean, you know, most people that will be watching the channel will have at least heard of that kind of phrase. And so, you know, it gets bandied about a bit, but it is true. It is legalese, isn't it?
Yeah, it's legalese. It's legalese. Because legalese is legal words. Legal words put you into a legal framework. And then
you're kind of like under their authority or under their jurisdiction is the word that they would use, yeah?
Yeah, because if you act in a legal capacity, you have duties and liabilities under the legal framework.
So so you know, obviously we've known each other quite a while, and we talk about this thing quite a lot. So, you know, once you've accepted the title, in other words, is what we call it. Now you accept the title, you have to use those duties and obligations, or you have to fulfill those duties and obligations that go along with accepting the title.
Yeah, because it's a role. You know, when you accept a title or a position, you know, for example, I'll go to the court in a second, but for example, you know, a Mr. is a title that I wasn't given. My mum didn't call me Mr. A doctor, an employer, an employee. These all take on what we call personas. And, you know, the word persona comes from Latin, which is why they make it, that's where we know it today as person. So when you take on a persona, you take on a personality. So then it's like, oh, if you're a doctor, you're taking on a doctor's personality, and you got to act like a doctor and be expected to know the duties and liabilities of a doctor. And therefore, anything you do wrong in that capacity, you'll be bound by the legal framework of that capacity. You know, when you wake up in the morning, you know, the best example I can give is when you wake up in the morning, you wake up from your bed, you're living in your home, you're in your, what I would consider your private capacity. So then I might leave the morning and I might go to work. You know, I could be an employer, I could be an employee. As soon as I step into that realm, I'm not in my private capacity, because we all know that when you go to work and you act as the employee, your character changes. You know, you're not yourself. When you talk to your customers, you're not talking to them in your normal self. You've got a little bit of an act and a personality going on. That is the perfect example of where you're acting. And if you're acting, you're not yourself. So, you know, your private capacity is one thing, and your, you know, commercial, you know, the legal capacity is a commercial capacity, because you're kind of engaging in like commercial ways, and, you know, they see it as like doing business. You know, when you're in your private capacity, I'm not doing business with anybody. Anyone who comes to my door is somebody I know. So if you come to my door and I don't know you, what business do you think you have with me? I'm living privately. And if you do think you have business with me, you have to establish very quickly what that business is and where you seem to think to have that interest, you know, what basis you have for this. And then I'll take you through the question of proving it. Because, you know, I don't remember having business with lots of people that might knock at my door.
I mean, that's a perfect example of like, you know, living in the private, which like a lot of people still they don't comprehend. They don't like fully get, you know. And I think really when you right, as Dayne, have attended the court, what you've done is you've actually just went there as Dayne in his private capacity. So doing that, right, can you just sort of like I mean, obviously I've read it and everything, but I really enjoy this bit, and I'd like you to tell others, because I know a lot of people talk about it that have never done it or never been there. Okay, when you've come in and let's just say you're sitting down, you just mentioned it there before, so you know there's obviously been a dialogue coming from the judge, who would have expected everything to be exactly as it should be for every day of his working life. Okay.
Yeah.
So he's come in, right? It would have been like either the usher or the court clerk, whoever it had been there, when everyone right, or please rise, or whatever it is that they say, all rise.
Yeah.
And so you haven't. So then, come on, tell us what happened. Go through what was said and what was the result.
Yeah. So this is a little bit of role play that's actually in the book, the dialogue. So clerk says, "All rise." Judge comes out. I stay seated. Judge turns and looks to me, and he says, quite angrily, like frustrated, he's like, "Are you not going to stand up for me?" It's quite intimidating. It's my first time ever being in court, and I got the first thing that said to me is the judge looking at me angrily and saying, "Are you not going to stand up for me?" Now, Carl's little method is to, play stupid. We act like a sheep in wolf's clothing as such. So I just said, "I've never been to court, Judge. Are you meant to stand up?" And he said, "It's customary to stand up." So then I used a legalese word called required. I said, "Am I required to stand up?" Required secretly means, do I have to by right and authority? And he turned around and said, "No, you're not required to stand up. Please feel free to stay seated." Now, my mum was the only one in the court with me. So she's the only one who witnessed all of this happening. And in my head, I was like, oh my God, that actually worked. All right, that's step one. I literally did the role play the night before with Carl. And this is literally how it went. So step one, we got that out of the way. So then he just goes to the next step is to introduce the parties so he can identify who's at court. Introduce the claimant first, and then introduce, find out well, she's the applicant and I was the respondent. So he introduced the respondent. So he's introduced, is Mr. Dayne blah, blah, blah here? So that's the second step, is I deny being the Mr. Now I said, no, I'm not Mr. blah, blah, blah. But when I say these things, everything you say, you have to have good reason as to why you say it. Otherwise, you sound like you don't know what you're talking about. So I said, no, I'm not the Mr. I made what we call a notice of special appearance, which I basically wrote on paper in hand, I, Dayne, of the family or of the house, blah, blah, come at this day in court, So then this is me and this is who I am in court today. For example, he doesn't know who I am. Imagine if I'm a prince from my home country. I could be coming as, some type of prince, from a chief, prince of a chief, from some tribe or something from my home country. He's thinking the title Mr. blah, blah, blah is coming in. I'm coming as my living self. So I present the notice of special appearance, basically telling him that I'm here today in my private capacity. That's like the unsaid of what's going on. So I had that sign. I autographed it, not a sign. I autographed it and I put my thumbprint over it. These actions bring it to life because fictitious entities can't do these actions. So then I explained to him, I'm not called Mr. for, by reason that my mother didn't call me Mr. and I don't have a prefix before my name. Very reasonable reasons of why I would not admit to being a Mr. or why I couldn't, relate to being a Mr. So then he's like, okay. So then he called me the respondent. And again, that's a legal word. That's a personality. I can't be a respondent because I don't know how to act as a respondent. Remember, these legal words, I'm not legally trained and I don't have any legal qualifications. So why would I ever admit to understanding what legal definitions mean? So I don't know how to act like a respondent and I don't know what it means to act like a respondent. So, if you're referring to me, please just call me Dayne, as per the notice of special appearance that I just gave you. He then kind of moved on. We just went into the conversation. Mum did her side. I did my side. And I was just trying to play this no jurisdiction route. So when he was talking about my daughter, he was saying, we're talking about your daughter. And Carl taught me you should call your children property. Now, when I first got told this by Carl, property sounds very unnatural. It's not something you want to refer to your children as property. I don't think most people would want to say that they're children of your property, but in a court of law, when you're in that setting, the words get changed. So, when you're outside, we have our normal everyday words, we communicate with each other. But as soon as you step into any legal grounds, the definitions of the words are changing in the legalese type of context. So using their words can give the judge jurisdiction. So if you say the word child, if I admitted, yeah, it's my child, I'm giving the judge jurisdiction because I'm not separating, it's not your child, it's your property. Now, a lot of people don't want to admit that it's property. A lot of people got a lot of opinions about whether your kids can be called your property. So what you do is you identify the elements that consider property for one in the realm. Now, you've got two ways of establishing property. You have a legal way, and you have what we might call the way in equity. You know, we just use equity for the ease of the word and the conversation. You know, I just say private, it just keeps the language easier. You know, lots of people use common law, these things. Using all these terms can just muddy like definitions. So I just use private. So the elements to property are he who authors or creates, because if you did have property, you would either create or author it. That's, you know, first point of proof. The second one is he who maintains, because if you did have property, you would maintain your property. And usually he who benefits, you know, if you benefit from your property, you know, you should really benefit from your property. Now, this could go for anything to establish property. So I'm just using it in the version of, you know, my child, because I am he who authors, you know, and creates. So, you know, between you and the mum, you know, the seed and the womb, all that kind of stuff, you create the child together. I do maintain, because, you know, I look after my child, I feed her, water, all that kind of stuff. And I do benefit, you know, from, you know, the love, joy, all those kind of things. I'm the one who benefits. So now that we establish these rights of property, so, you know, as I did this with him, and I said, property first, he said, what do you mean property? You mean your child? I was like, no, I mean property. And then he accused me. He said, oh, you're speaking very strange language. You know, don't you mean your daughter? And this is his way of trying to make me question myself. So I said, Judge, are you a high court judge? I just want to confirm that you are of the high court level. He said, yes. I said, well, by law, I am he who creates, authors, he who maintains, and he who benefits, therefore establishing all the elements to property. And here's my property, Exhibit A, which was a picture of my daughter. And he said, oh, yes, you're correct. So I was like, oh, you know, oh, that's checkpoint 2. And I was quite surprised by that. I wasn't fully sure. Okay, where do I go next then? He ended up turning around saying it's her property too, which is right. But the problem is it's not for him to tell her that. You know, you know, as the individual, you need to know what your property is, and if you can't explain yourself, then you don't know. So where he suggested it for her, I just said, you know, are you here today to be impartial? Yeah. So I was like, are you here today to be impartial, Judge? He's like, yes. I said, well, could you please stop coaching the other party? And he actually said, oh, I'm sorry, I won't do that again.
Yeah.
And I was,
so, I mean, the thing is, it's like what you've done is you've established, you know, that he's a high court judge. So therefore, he knows exactly what's going on. And, you know, if you were wrong, then you would not have got past that point.
Yeah, you know, they would probably accuse me of like, and they'd probably accuse you of lacking mental capacity. This is the angle that they come from when they don't.
Of course, you know, you sound a little bit mad. But the thing is as well, you know, I mean, and I've had this because I've always said this. I've looked at two different ways of doing it: the legal way and the lawful way. When you're talking about your offspring, sons and daughters, I always refer to them as sons and daughters, never children, because I know that's a legal title. So that's coming from Carl Lentz and John Little, who I'll mention in a while. But it's all of the same kind of area where they're talking about what is property to man when we're talking about the law. And the words are just different. You know, we don't, if you're going to say, like, you're not going to treat like your daughter as you know, like a piece of furniture, right? It's just the term for the court in law. Right. Yes. Obviously, you've got your daughter. Then you said the benefit is you're getting, you know, the love and the affection, you know, and the relationship there with your daughter. It's just the term property to do with the law. So you're not demeaning them in any way.
No.
Right. It's just to be used like in a court of law.
Yeah.
So these things here, so like obviously, if you're authoring or creating, well, it is obviously jointly for sure with the mother, but you did create, all right? You know, there, and obviously maintaining is natural. And obviously you have to feed them, clothe them, look after them, have them in the house so that you're not letting them get cold. So you're maintaining them for sure. And then benefits, again, we just said that. So like, you know, the love and affection of the relationship is there. So that is definitely a benefit. So
Yeah.
I just want to go over that because I've had this stick tons of times before, and people try to twist it, make it just like, you know, what the judge was trying to twist it a bit there. What do you mean, property? You know, but in the law sense, those words are exactly how you have to refer to it if you want to take in some way that is you winning jurisdiction completely.
Yeah, because you have to understand that, you know, if a judge is there to be impartial, you've got to put yourself in the mind of him. You know, he doesn't know who we are, so now he's got to take on what you say as to try and, you know, believe you as such. So then when you're coming with the correct terminology, you're identifying, you know, the whole point you go into court is to direct the judge with, here's what I say, here's how it works, and here's what you should do. You know, and that's ultimately what you're trying to achieve. So you're directing him, not having him direct you. Now, in regards to him being a high court judge, just to give clarity, you know, the family court division doesn't get held at the high court, you know, which people might think the building in London, the high court building in London. The family division runs in the family courts in a circuit. So when you first start, you'll be at a county court level judge. If they can't make a determination, you go to the district level judge, and then you go to the high court level judge. So he was technically, at the time it was 2021, so he was a high court level judge on the Queen's Bench division. Therefore, he sits in the family division, but he now hears things under the high court, you know, the high jurisdiction. So, you know, he can deal with things like human rights cases, because you can't talk about human rights in the lower courts. They can't hear that. So you need a judge of the right level to hear your position as such. So this position in the lower courts, they can't hear it. So, you know, it will get moved up to the, you know, technically the higher court. That's not how I got moved up to the high court. I had a different way, which we'll get through. But that's the reason why this particular judge was able to hear my words, because he has the jurisdiction to go between all the different areas, you know, and that's what the high court judge does. So just to bring clarity on the high court side of it, and that's why he was able to recognize my words.
No, that's absolutely perfect explanation. Yeah. So I think a lot of cases, or that when you hear people have went into court and they're at a magistrate's level even, and they're trying to use these words, and they're not getting anywhere. You know, what you need to do is you need to get a hearing and move it up.
Yeah. If you find like you've gone to court and you feel like you had a good case and you feel like maybe you got railroaded, the court process is, if you don't like the decision, appeal it to the high court. And then you go through the same argument. You know, if your argument's clear and concise and, you know, watertight, then they should hear it out, and, you know, hopefully it goes your way. And if you get appealed again, you go to the next, you appeal it again. That's the process that we are meant to actually know how to pursue. You know, you're meant to you're meant to be able to go to court and know what court to file in, know what your claim is, you know, put it in the right court that they can handle it, ask for the remedy that they can give you, you know, because let's say if you do everything right and then I ask for a remedy that isn't within the court's jurisdiction, they then get jurisdiction back over you, because you now sound like you don't know what you're talking about. If you've come to court and you want to play the game, you should know the full game. Rightly so.
Absolutely.
Right, you know,
yeah, so. Definitely. And I just think that too many people sort of like jump in at the deep end without actually doing the research and finding out exactly how they're supposed to talk. I think behave, yes, but like definitely talk. The language is the most important thing.
Yeah, and you know, I was a beginner at these times, so you know, I didn't have the level of comprehension I do now. When it started in the county and the district court, and I didn't know this information at the time. So the way that got pushed up to the high court is because my let's say argument, for the ease of word, was the fact that the mother and I had already made an agreement outside of the court that my daughter would live with me. You know, that's a contractual agreement. Technically, you don't have to. Contracts can be, you know, implied, verbal, or in writing. So this was clearly a verbal agreement. I've got text messages of it. I can prove it. So now that I know this more, that could be a contractual argument, and therefore they don't have the right to interfere with, you know, a private contract. In the county and district court, that kind of was my argument. I just didn't know it as comprehensively as I do now. I just was confused. You know, I was like, well, my daughter lives with me. You know, we made an agreement. Why would how does this arise that this can happen? You know, how can you now override an agreement we've made? You know, a lot of the county and the district court was saying, oh, I should give her, you know, to the mum. And I just lacked understanding. I was like, well, what do you mean? Why would I do that? We've both agreed this. You know, it doesn't make sense. And it was only later on that I found that lack of understanding was exactly why they couldn't make the determination, because they need you to understand what's gone on today. You know, they need agreement from both parties, and if both parties agree, then it's just become a negotiation of what happens after. Like with anything, you need to get acceptance. After acceptance is negotiation. So I play the same kind of game back. You know, I need you to accept this as my property. After we accept this as my property, then we negotiate, you know, what you think you can or can't tell me. That's yeah, the county district court, I lacked understanding, which actually, you know, even in a district court, the mother was in a different country, and the district court judge is telling me that, oh, when she comes back, send your daughter back to her. I'm like, well, why would I do that? Why would I have to sit and wait until she comes back to do that? It just doesn't make sense. She got very frustrated, actually, and she ended up, well, we're just going to have to appeal this to send this to the High Court. I was like, okay, I guess so. So when it did get to the High Court judge, at the same time, I did use that same argument as well, which was another winning argument. The fact that we've made this agreement prior, so, you know, how can they come in and just try to, you know, disrupt the agreement? I didn't know at the time it was, you know, to use the contract law kind of legislation, because you can say, oh no, here's the contract law legislation that you guys follow, so, you know, follow your own rules.
Yeah,
I didn't know that.
I'm glad you said that. You know, like, because the contract law, right? Yeah, you brought it in. It's good that you've had that experience, because now I
didn't bring it into this. I didn't bring it into this court case because I wasn't comprehensive of that's how. But now I understand more. That's the best way to then secure what I'm saying. You know, this is a private contract between me and the mum. I know that you recognize this because you've made a legislation called the, you know, the Rights to Third Parties Contract Act, or whatever it's called. So that just shows me that you recognize what I'm talking about. I'm not using it because I rely on it. I'm just using this legislation to remind you that you recognize this. And this is actually, funny enough. Yeah, funny enough, this is a position that I'm coming with me. So why don't you recognize what your own rules in a nutshell?
Yeah, so they are actually bound by them, is the thing. You've used them just because, well, it's natural, it's normal, because you've made an agreement. You found out later that they would call it a contract. You didn't know that. Yeah. You just thought you were making an agreement. Yeah, so you've made an agreement as natural as it is, but they have to follow their own rules and regulations and statute, if you want to call it, because that's what they call it, an act of parliament they made up, right? So they're bound by it. You're not.
Yeah.
But they are, for sure. So they have to follow, and just because it's coincidental that your agreement fits in with theirs, so they have to follow that and recognize what you're saying.
Yeah, and that's a lot of stuff I've kind of been working on since, you know, how to master that kind of concept. So day one was quite a quick day. So we went through these checkpoints, don't stand up, did the whole Mr. thing, you know, did the property thing, and then as we went into the actual case, I wasn't served the mum's paperwork in time, so I was able to have that adjourned, which I was quite happy with, because I was thinking, oh, I can get out of here and maybe learn some more. So I got that adjourned, and then the new date was set for 6 months later, a 2-day trial or case, whatever you want to call it. So then I spent that time doing a lot more research and trying to, you know, really craft my position. You know, I was adamant that I didn't want to give jurisdiction. So I, you know, when we went to the second day now, 6 months later, we had the same kind of opening. You know, I presented my special appearance again. You know, did a repeat of everything. We got to the property thing again, said I'm not the Mr. again. And then obviously the mum had her application, said what she said. And then I said what I said. We did the property argument. And the social services were actually involved in this case as well. You know, the mum made some accusations against me. You know, anyone can make up accusations at any time, you know. So obviously I believe she was just doing it because it's an easy thing to throw at a man, you know, as a woman, you know, when it comes to a child thing, say, oh, dad's this, or dad's aggressive, dad's, you know, violent, whatever you want to say. So I just reminded the court that, you know, all of these accusations are unfounded, because never have I seen a police report, never have I been visited by the police for any of these accusations. They've not been documented anywhere. So technically, how true can they be? If they haven't been documented, there's no evidence of them. I then just reminded the judge that these have to be thrown out of court, because they could be seen as malicious, vexatious, or even hearsay and speculation. You can't just say, because if we took that concept, that means anyone could go around saying anything about anyone. And what are we just going to believe it?
Yeah.
Without basis. So that actually quickly shut down any accusations, which in my book I've got like a little sentence that if somebody accuses you of something, they have to have a reason to back up why they're accusing you of this. They can't just say, oh, you're violent, and then have no proof of it, because then I could just turn around and say the same thing. So it's, when you get accused in a court, it's for you to bring the words to life. The judge is not just gonna do the work for you and presume, well, she hasn't got any evidence, so it can't be true. You have to say, well, judge, these accusations are false. The reason why I say that they're false is because they're not documented. There's been no record of them, so these are considered unfounded, and the court can't hear such unfounded and reckless statements. And then the judge like, oh yeah, that makes sense. So I'm directing him to listen to that. These accusations need to be shut down. So, lots of, I just want to get that out of the way for a lot of people that deal with, accusations, if they're false. That's how you turn an accusation to a false accusation. Because if you don't say that, then, remember, this guy doesn't know you. She says stuff about you, you don't defend it, then it might be true what she's saying.
Unfortunately, that's the way of the world. It's like too many people make accusations of others, and with absolutely no proof of anything whatsoever. But, mud sticks, as they say. You can say anything you want, and but like in a court, at least you have the opportunity to actually say, well, look, show us the proof or be quiet. And in the court, they have to do that. So that's the best way of getting sort of like rid of all the nonsense, really, isn't it? So that's good.
And one thing to recognize about this whole not giving jurisdiction route, let's say if I went, because I got a court order, so I got a court order because I recognized a legal point that I would definitely win on. As I was going through this, I was thinking about it a lot more, and I was thinking, how could I definitely win on this? So I thought about another concept that I definitely, and I did win on that point. So I switched between, and the thing is, when you give your notice of special appearance to show who you really are, you can kind of switch into their realm and outside of their realm a little bit. I can go into their stories, but say, well, that doesn't actually apply to me, because remember, judge, I'm here by special appearance. So, don't worry about the rest. What was I going to say? So so when you don't play when you play the jurisdiction, you don't give jurisdiction. In this family type of situation, the only outcome that could have happened if I didn't give the judge jurisdiction would be he would have to dismiss the application. It's the only thing he can do, because if you don't have jurisdiction of me, you can't even make an order in my name, because I'm not, you don't have the jurisdiction to do that. So if I did fully play the no jurisdiction card, then the only result would have been the judge dismissing the application. Now, if I were to do that, that means the mother could keep reapplying.
Right.
And so to stop that from happening, I thought, well, I'd rather get a little order in place, because at least it will make her think that she can't breach the order, and that'll create for me a layer of security, when it comes to the mom's perspective of how this stuff works. So I kind of switched my gameplay a little bit, and I found a point of law that he has to follow, and he couldn't get out of it. So I'm not going to say that's in the books, so if you want to find out, that's all explained in the book. And that's just want people to understand about when you don't play when you play the jurisdiction card. If I were to play it in the family law court, the outcome would have been dismissal. And that's the outcome usually if you go to a court and not give jurisdiction. So I wouldn't recommend this. I said before, I wouldn't recommend this for families that is mum versus dad, because when it is mum versus dad, child arrangements is quite an accepted thing amongst everyone. Even the court wants you to, the court wants you to settle it privately. They don't want you to come to court for child arrangements, because it looks like, they want you to be mature adults about it. You should deal with that privately and be mature about the arrangements. We all know it's 50-50 responsibility. We all recognize it's 50-50 responsibility. So therefore, you know, it is quite fair to go in with, you know, your legal grounds and follow that legal route, because they are quite fair with how they deal with the, you know, the equal 50-50 split with mums, dads, and children. So if, you know, for most people, if they do have child arrangements issues, it's quite simple. Now that I know a lot more, it's actually quite simple. You know, follow their grounds. You know, the only time I would say to play the non-jurisdiction game is if you have corporations coming after you. These are entities. These are not real people. You know, like the social services, because that's what Carl Lentz did. Carl had the American social services, you know, take his kids. So he used the argument he used when the corporations coming after you for your children was they were interfering with his right to property. Well, they were without right interfering with his right to property, because they don't have a right to interfere with his right to property unless they can prove a right.
Which is exactly, you know, like because obviously I've like listened a lot to Carl Lentz myself, and the reason why I listen to him is because I was like training and still actually listen with a guy called John Little, who was trained specifically, you know, by Carl Lentz, and it was on a family. And they had done the same to him. They had took his children.
They did.
Probably because he was always standing up to the law, standing up to court, etc., etc. And he filed the notice and the claim exactly the same there. Went in by special appearance, not general appearance. And it was the whole point. Why are you interfering with my property? You know, and within 24 hours, he had his children back. Because again, just using the lawful words, you know, with compensation as well, you know.
Oh, amazing.
So
yeah,
American, you know, that's the
yeah,
way that they act, isn't it? You know, so but using the law, using those words, right? And again, we're not talking about like, you know, some kind of like slavery concept. It's simply in the law, that is how it actually states that they are your property, and you have to actually look after the property. It's your job in a way, in law, you know, to look after your property, look after your sons and daughters, or a child, as they would actually put it, to try and get it on the legal sense. But and he got his children returned to him within 24 hours plus whatever compensation. But and it's just about language. It's not attitude. You know, you're not going to treat them like your couch or your car, right? They obviously, there's a loving relationship in there, and which is the benefit side of it. But it's got to be the language that we use to be able to put it across to the court that you know what you're doing and that you're standing under the law.
Yeah, because, you know, a lot of people have lots of opinions about whether this is real or, you know, whether it's, you know, it really works and stuff like that. So remember, I didn't know this when I started. I learned it. I tried it. For me, in my life and my truth, I got admittance from, you know, the High Court judge. He admitted that this is considered my property after I show him I know what I'm talking about. He, you know, he admitted it. He said, yes, you're quite correct. So, you know, whether people want to believe or disbelieve it or not, that's fine for them. You know, for me and my truth, I 100% believe it. You had somebody else meet the same, you know, find Carl, who I met, who, you know, I found, and, you know, me and you were talking, and I don't know your friend John, and, you know, I told you about Carl, and it was you said, oh yeah, my friend used Carl as well, you know, and John did it. So proving that, you know, for his truth, it worked. So he doesn't, you know, it's not like I'm not the only one doing this. You know, I learned there's people out here that know about this way before, you know, for years. So, you know, for people who want to disbelieve, you know, that's up to them. But there's people out here doing this and have done it. You know, me being one of them now. So, you know, anyone could be as skeptical as they want. You know, all I say is, you know, go to court, try it. You know, if you haven't tried it, what can you really say about it?
The good thing for others right now is that they can actually get the your experience, so they can actually get a hold of the book, read the book, and see exactly what happened. But obviously it's good because you give a background to everything as well. You just don't say, oh well, this is what I said and this is what he said, and end of story. You know, you actually go through the background, the explanation, and obviously talk about Carl as well, and how things sort of like developed from there. So the good thing is, through your experience, because not everybody has got sort of like I don't want to say bad things about people, but you know, they haven't got that in them to be able to live through it and learn through it as they're doing it. You know, whereas like you were straight in at the sharp end, maybe that was a necessity and you had to be challenged that way for you. But obviously, you know, my sort of like friendship with you, you know, over the last few years, you know, I've been able to listen to you quite a lot, and you do dive deep in and also like pick up a lot, and you've got a very natural way, I think, of absorbing it and maintaining the education, you know, because the conversations that we get into are quite deep sometimes. And it's good to be able to know that those bits of law. So now you've been able to put that into a book to benefit mankind so that
Hopefully.
they can actually learn that as well. But it, you know, I think it's fantastic, you know, because not only is it really giving in-depth knowledge, but it's the experience of you, what you actually went through. It is your story.
Yeah, and you know, it's not a law book. You know, I'm not trying to, you know, I'm not trying to say, oh, this is a law book. I'm not legally trained. I'm not legally qualified. I can't give out legal advice. So it's not a law book. It's just a reflection of my experience and the things that I felt like I identified. You know, I try to. My goal is to simplify these complexities. You know, the courts and stuff, they come across very complex. So now that I've been through it, you know, I went to the family court 3 times. I've helped a few other people outside. You know, I've helped my friend for a housing repossession. That wasn't a mortgage repossession. It was the accusation of having a principal home elsewhere, you know, breaching the terms and conditions and subletting the property. Those were the 3 arguments. You know, I used, I did not give the judge jurisdiction, but I used my understanding of this is what the judge wants to hear. This is, you know, if somebody did have a principal home elsewhere, this is the evidence that they would need to prove that. You know, if you're saying someone's got a principal home elsewhere, your only definitive evidence would be the title deeds. Now, she didn't even have a title deeds because she doesn't have a principal home elsewhere. You know, ergo, everything they're saying is, you know, speculation, trying to, you know, overweigh the probability that it does seem like that. So, you know, my our position was kind of batted against that. You know, she doesn't have a principal home elsewhere. This is her home. She doesn't have a title deed anywhere. You know, and then X, Y, and Z around each other point of the conversation to say that ultimately they can believe what they want. Anyone can believe what they want, you know, when they have certain information presented, but their belief doesn't mean it's true. You know, these are only things that mean it's fully true. And if you don't have that, your belief can only be speculative. You know, it goes into that nature. So that's what I'm trying to do, is simplify how people view a court, what people think of a court, you know, and ultimately, ideally, in the ideal world, is hopefully we all come to the same understanding, and then everybody can access the court, because the court's there for you to remedy yourself should you need a remedy. You know, if someone does you a wrong, you should be able to know how to use the court to get that remedy, and that's how they treat you. It's just that we have lost that knowledge because we're distracted, too busy. They don't want you to know about that. You know, when you do look up about how to research this, there's no information out there. It's either you got to practice law, speak to a lawyer who you might not even get the full truth off of, or you know, where else do you find out about this? You know, hopefully try to speak to people who've been through the experience.
Yeah, I mean, that's the thing. It is, you know, you can't go on to say, you know, a search engine or something because it's shut down anyway. It's all maintained and controlled, you know, all censored. So they're not going to allow you. And this is the true knowledge. This is what is true. This is like how to talk the correct language in a court of law, not of legal. So when you're going to say a solicitor or a barrister or whatever, they're just going to completely drain your wallet, you know, your bank account and everything else that you've got. And this is the really the way that I've found lately, when I've been looking at it more and more and more, is that they've been trying to remove justice from man and woman, because if you can't afford it, you're not getting it, really. You know, whereas obviously if you can spend time to research and learn like what you have done, then you have the ability to go and get your own justice and put your point across, at least anyway. Obviously, this is great because they found in your favor, because you know your case was sound and your knowledge was sound, so the language is sound, and that's really where it cuts down to. If you've got a good sort of like solid case in your favor, then you use the correct language, then you're probably going to have a favorable outcome, you know. So you can't go in for a bad reason, is what I'm saying.
No, yeah, and your position has to be compelling. You know, if you say something, back it up with something. That's what makes it compelling. Whoever's the most compelling sounds like they're the one that's right. Because remember, this is a neutral guy. You know, there is no truth. There's your truth and their truth, and everyone else got their own truth. So how do I? You know, it's more of a bit of a psychology game. You know, don't. It'll be silly to upset the judge, because if you want a decision in your name, you know, a lot of people say, "Oh, let's play that straw man argument. I'm not the name." You know, blah blah blah. They're not wrong in saying that, but I feel like most people are taking the wrong approach to identify that. You know, when I did the whole Mr. argument, that is technically saying I'm not the straw man, but without saying I'm not the straw man.
Without being argumentative.
Yeah, because you know, if you're argumentative, you create controversy. If you create controversy, they get jurisdiction over you. So when I was, you know, conducting myself, I was trying to be calm, clear, concise. You know, I'm not here to argue. I'm just here to express my position. Here's what it sounds like. You know, why would I get angry about that? Why would I feel, you know, emotional if somebody says something that I don't agree with? People can say what they want. I don't, you know, we don't have to agree with it, but
that word you just used there called controversy, you know, I mean, that the whole thing about like lawful and legal, which, you know, anyone who's listened to Carl Lentz at all, or the other people that I have mentioned, then, you know, you what they say point blank is you have to live without controversy. If you want to be lawful, right, you have to remove all controversy from your life, lawful and legal, and, you know, stay away from controversy, because the legal network, the legal system thrives on controversy. Therefore, that's how all the solicitors or lawyers of different countries, barristers, whatever you want to call it, that's how they make their living. That's how they make their money, by controversy of others, because they have not got the ability to stand without controversy in law.
Yeah, because like, okay, if you're arguing, then you need a third party, i.e. the courts, to stop the arguing. You know, you guys obviously need help, because you know, creating controversy. People who know what they're doing and, you know, feel confident and comfortable, they don't need to argue. You know, someone could, for example, if you came up to me and said, "Oh, I don't like your clothes or the way your hair," you know, someone can say that. They've got the right to say that. Now, my reaction is what creates the controversy. So if I said something negative towards them, I would be considered the controversial one, because I reacted controversially. You know, going up and say you don't like my hair is not necessarily controversial. It's your opinion. I create the controversy by the reaction of your opinion, and therefore I'm the controversial one if I react badly. Because you could, you know, so the best way to, if someone said, "Oh, I don't like your hair," to not be controversial, I could say, you know, "I'm sorry you feel like that," or I could even ask you a question: "What is it that you don't like about my hair?" You know what I mean? And that's not creating. That's a way to answer, to not create controversy. These are the little kind of plays, you know, in between the lines. That's what's kind of going on. So in my book, I've got, you know, the explanation's got my story, how I handled it, my conversation with the judge, and then I've also put the legal framework, because part of what I've realized, you know, since was I was honing in on the judge is the person that you need to appease or whatever. You know, it's the judge. You know, the judge makes the decision, so he's the guy who I need to know how to talk to. Everybody else I consider minions. You know, everybody else is just doing their job. But most people just doing their job don't have the legal qualifications, you know, to say what they say. You know, if you go down the shop, someone won't let you in. That person's not legally qualified. So how can they stop you under legal grounds when they clearly don't have the qualifications? You know, you can't stop me then, because you need to, you know, if you want to stop me from doing something, or, you know, like with COVID, you stop you going into a shop and the security guard stopping you. If he doesn't have legal qualifications, he doesn't have the capacity to stop me, because he can't talk about any legal ramifications. And, you know, if he admits he has no legal qualifications. So we bring people out into, you know, those types of areas. So focusing on the judge wants what the judge needs to hear. In the book, I've kind of put the legal framework, because that's how he makes his determinations on the legal side. So if you can understand his legal side, you can use, you know, certain aspects in your position of your you know, your paperwork to hone in on that and say, you know, the biggest thing in family courts is everything has to be for the best interest of the children. So that, you know, and so everything you talk about, you should then always say, well, you know, I said this because this is the best interest for the children, and keep compounding that. And then to him, it's like, yeah, well, my whole decision has to be for the best interest of the children. And if this person keeps saying things that support that, sounds good.
Yeah, exactly. Just going back to that thing that you said about like the lockdown, we won't say the Charlie word, but you know, because you still get a bit funny reaction off certain like YouTube, etc. But when I was going through the equity knowledge share, right, which was not Carl Lentz or John Little, but it was completely different. But I thought it really was. It kind of recognized each other, I thought, and that was purely on equity. They called it equity. This is just purely equity. I'm not mixing it with, this is what they would speak.
Yeah.
And then the guy, he says, I'll tell you a point blank on equity. And he said, I went to whatever, he said a word that was a common name of a shop in America. I'd never heard of it before. I actually thought he was talking about like some kind of chocolate confectionery in England. I'm like, what? It's like totally lost me. Anyway, but they just went in there to pay a phone bill or something. So whoever it was like, you can't come in, you haven't got a mask on, right? And he was like, oh, I didn't realize you were a lawyer. Are you a lawyer? And they're like, what are you talking about? And he said, well, you're making a legal actual decision here. And they're like, totally. And in the end, they were just breaking down and saying, well, look, I'm just trying to do my job. He went, well, take the bill then.
Yeah, exactly.
So
do your job.
Let him go.
Yeah. Your job doesn't come with any legal ramifications because you're not legally qualified. So let's just stick to your job. And, you know, that's, you know, since coming from court and and the 2020 issue, a lot of people's excuses were, I'm just doing my job. So then I picked up on that thing. Okay, well, everybody's trying to stop us with the basis that they're just doing their job. So then I need to now back engineer what it is that, what is their job, and do they have the authority and power to do this? Which is where, I brought me into the arguments of, asking people if they're legally qualified, because if you're not, then you can't tell me about ramifications, any legal consequences. And it's a good way to just help people know that, this is what your job is. So don't try and tell me X, Y, Z when you're here to do your job. So don't be ignorant of your job, and let me help you understand that you can't talk about X, Y, and Z. Because you did say you are here to do your job, aren't you? And you kind of bring them into a circle of a sentencing that they can't go anywhere from it.
Exactly, but that's the way. Really, that might seem very obscure to people. Think I thought he was talking about family law. I'm just trying to show the difference between legal and lawful, right? Whereas you have to be very specific in your language, and that's exactly what you've done, and that's why you have created the book to help others on there. So, I mean, how do, because obviously we'll get it in the links we'll put in there, but where do you go to get your book?
Oh, so my book's just only directly from my website. My website is www.lawbydejure. That's LORBYDEJURE.com. Now, the word law, LORE, is like the original folklore. Before they had the written law, there was kind of... the law was here before us, it's unwritten, it's those natural instinctive things, don't hurt anybody. Before any written law came, people were already living amongst each other, and they kind of knew to not cause anyone loss, harm, injury, or damage. Now, the written law reflected it as loss, harm, injury, or damage, but secretly those are instinctive knowings that we would naturally know. So when I talk about this, I just like to call that natural law, because that's what comes natural to me and my knowing. I don't need to go tell people you shouldn't hurt people. We should naturally know, some people that don't know that, that's why they go to prison. That's the right place for you. But naturally, I know not to do these wrongs. So that's for me where I like to call it natural law. So therefore, if I haven't done a wrong to somebody, who's coming for me for what? The only, if the only things you should not do is cause loss, harm, injury, or damage, or breach a contract, a willing agreement that you entered into. If you willingly entered into something, you breach it, then you should be consequenced. So people are now from the realm coming after me, family law, debts, whatever, ultimately, if I haven't done anybody wrong and I haven't breached a contract, what makes this person or corporation think that they can engage with me? And that's the aspect, same with the family law issue. The family law issue, the book is kind of, it's a split between the two different methods. Because I wanted to explain the Carl Lentz method, because I did try it.
Excuse me.
Okay. you know, the books, let me just show you the copy of the book. So, you know, the book's actually available in both paperback and hardback and a downloadable copy. So, you know, here's the I don't know if you can see on the screen. Can't really
Hang on,
see
I'll
it.
tell you what, let me share it. I'll share it on the screen. Give me a second. And then just get a better
View.
better picture there. Hang on, I'll just make it a little bit bigger. How do you do that though? Is that right? Oh yeah, there you go. Right, I'll come back in and I'll share the image there. Share screen. There it is, and share it. There we go.
Yeah, so you
Okay.
know, that's the you know the copy. There's the ebook form, it's hardback and paperback form. Because I know some people actually like to read physical books. You know, the ebook's really good for people because it's got examples of templates of my notice of special appearance. It's got examples of, you know, how you would write, you know, a claim or a defense. And it also has a real life example of somebody who I helped in a family law situation and they got what they wanted. You know, I consider that a win.
Cool.
If you go to court, get what you want. You know,
Sharing that.
so that's the ebook's really good for anyone who, you know, needs that content and wants, you know, kind of copy and paste it over, change up their information, you know, so it's relevant to them. And yeah, so the book's written with both of the you know, the private side, the non-jurisdiction side, and you know how, you know, the legal grounds and that kind of side. The reason why I've done that is because one, that's literally what I went through. The reason why I've got the two, because I remember I was at the beginning of my learning, so I didn't know everything. I was trying a method that I did trust and I believed in, and for me, I believe it did work and it was working. You know, throughout the court case, the judge just randomly got up and walked out, and I didn't realize why he did that. I've since found out, you know, and one of my friends made a video for it, but hopefully, you know, I'll be able to share that at some point in time. But I believe I did not give the judge jurisdiction. But like I said, if you don't give jurisdiction, they can only dismiss the case. So therefore, I changed my angle and tried to come on a legal binding that I, you know, solidly knew would bind him, which I've explained in the book. So that's why I've got those two angles, those two approaches in one, because that's how I lived it.
No, that's absolutely brilliant. So everybody just remember that then. Okay, so it's law, but the way that it's www.law, L-O-R-E, okay, lawbydejure.com. I will put the link in the description so you'll be able to see it, and we'll share that out there for everybody. And, you know, I've read through it, and, you know, to me, this is something that you, if you read it correctly, will be able to go back to time and time again and be able to adapt it to yourself. I mean, actually, I'll ask you, Dayne. I mean, you've done it for family law, okay? Because you were going through that. That's your whole story, that what you've made it for. But you could actually adapt this to be other parts of law as well. It doesn't have to just be the family. You can use this in other areas as well, can't you?
Yeah, for sure. Because technically, the non-jurisdiction argument in a nutshell was you are without right interfering with my right to property. Now, where I would explain the elements to establish property, that could come into anything, you know, for example, my book, I'm the author and creator, you know, I benefit from it and I maintain it. You know, obviously I maintain the writing, I maintain, you know, distributing it, all of those things. Therefore, it's my property. Now, if you can do this with anything and you can establish that, then I would suggest that you've got a great case of establishing your right to property. A good example of this is, I always use a car. Car's a good example. Let's say me and you were arguing about the ownership of a car, you know, and you say it's your property, and I say no, it's my property, and we go to a court and we're arguing this out. You know, if you evidence that you don't create a car, but let's say to switch over the creation or author of a car, I would say that you might have the receipt of purchase. Yeah. So if you have the receipt of purchase and you can prove that you benefit from it and you can prove that you maintain it, because somebody would do that for their property, they would maintain it and they benefit from it. So let's say if you go in and prove those elements, you know, in regards to the car for you, it's going to look like it's your property. So then if I'm coming in and claiming it's my property, I would have to be able to, evidence the same things that you did. But how can I if you can clearly evidence them? If you're benefiting and maintaining it, how could I can come and say I benefit and maintain from it? There's two ways to own property. There's the legal way, which is a title deed, and a car's a really good example for this because in America they get title deeds for a car. So I don't know if anyone watches Judge Judy. I watch quite a lot of Judge Judy, and she's always going on about when she gets car situations. She's always going on about who's got the title to the car. Whoever's got the title to the car is considered the legal owner. So now that we know that title deeds are the legal ownership, with a house, it's the title deeds for the house that gives you the legal ownership. The other ownership is equity. Equity is he who creates, authors, he who maintains, he who benefits. So now, when you get into, like, let's say the DVLA over here, I don't know who's got the title deeds off a car in England, but if I ever get a hold on those title deeds, then I can prove in the whole spectrum that I own this piece of property legally and equitably. So therefore, before those people that do the driving, the whole driving issue and they're traveling, I would only ever do the traveling stuff if you hold the title deeds to the document. If you hold the title deeds, travel all day long. And then trust me, they'll probably still take your car because remember, these people are not legally qualified. So they're just doing their job and what they think is their job. So they'll probably still take your car. But if ever you go to a court and prove to the judge that you hold the legal title and equitable title, I think you'll win all day long. One day I might try that.
We've actually tried, I know I don't want to go on too long, different area, but we've tried to get the legal titles, right? The certificate of the manufacturer's certificate of origin, even applied to it through like DVLA, trying to trace it, and they just point blank say, don't know anything you're talking about, completely deny knowledge of it. And we know that they know wherever it is, if they hold it, they've destroyed it or whatever, but we know we have not got legal title because it just tells you are the keeper and nothing. I haven't even got that actually, but never mind.
So, establishing, we can clearly establish property, whether people want to, believe it or not. For me, I've got my first-hand evidence of that. Your friend John, who found his information independently from me. I don't know John. I didn't know you at the time. So that when I was telling you about my story, it was you who said, "Oh, I've heard of Carl's friend." You had your own friend who used Carl.
Yeah.
So this is help to show people, I'm not making it up. When I went to the court, I'm not coming on the ground like I'm not making this up, Judge. Here's why I'm saying this. Your own legislations, in certain areas, prove that too. So I'm not making it up.
Yeah, I mean, and the good thing now is for others is that they've got like not only your experience. I mean, they can listen to what I'm saying and go and find John himself, and listen to them stories. But the fact is that you've gone through it and you've wrote the book about it, and that is available. So make sure again, everyone. Okay, that we'll go www.lawbydejure.com. I'll put the link in the actual description. But make sure that you go and check that book out. So is there anything else you want to say just before we finish then?
Not really. Hopefully I'll try and make some videos as well for a little YouTube channel. Hopefully get some information, maybe help people with certain, understandings. But ultimately, this is the family law book. It's there to simplify, what we thought was complex. So, hopefully I've simplified a lot. I've spoke about a lot. I've tried to identify what it is that the court would like to hear from you, and it's for you to construct your position in that manner. That's the best way I can say to deal with it. It's not legal advice, it's not a law book, it's just somebody who's gone through something telling you their experience and the things that I feel like I identified, which I feel people would agree with.
Excellent. I mean, it's your story is what it is, and it's what is actually true for you because you've lived through it. So nobody could argue that, could they?
Exactly.
Okay, so again, thank you for coming along. I think that's incredibly interesting, and you can further that interest by getting a hold of the book and reading the book, because it is a great read, and the information in there is very usable for many different situations, as Dayne's just said as well. Okay, So again, thank you very much for listening. Thank you, Dayne, for coming along and sharing your story.
Yeah, no problem. And also, you know, on my website is my contact details. You can email, you know, if you need to get hold of me, all those usual routes.
Brilliant.
So, yeah.
Absolutely brilliant. Okay. Thank you very much.
Thanks, Peter.